Hello and welcome to all the CA Foundation students. Yes, guys, can you hear me clearly? Can you hear me properly? Yes, guys, just give me a confirmation that you can hear me. Can you hear me, guys? Hi, good evening, everyone. Good evening, Siddesh, Manish. Yes, all right, you can hear me. I'm so glad to know that. Okay. In today's session, we are quickly going to discuss the RTP for June 22, and this lecture is going to be in English only for all my dear students. And here we have special handwritten notes for you. Okay, as always, I prefer giving simplified notes to you. At Theory Masters Learning, my aim is to simplify law for you, and that is what I always try. So, to simplify the answers, to simplify the provisions, you will find these handwritten notes. And I'm very sure you would want to download these notes as soon as possible. Yes. So you can go to the e-note section of my website, theorymasterslearning.com. I have already uploaded this sheet. Okay. So you can immediately go and download. There's no registration process. So go and immediately download the solution for you and learn law in a very simplified manner with me. Okay. So guys, are you ready for this amazing and interactive session for RTP discussion? Now, I'm not going to tell you the answers. You will tell me what you would have written in this answer if it was asked in the exam. Okay. So let's see whether you are ready for the exam, whether whatever you had studied in class, whether you remember. I am going to discuss the answer with you, but more importantly, I am going to tell you what you are expected to write in the answer. See, many a times we know the answer, but we don't know what to write, how much to write, how to frame the answer, how to start the answer, what is the expectation of the examiner, what is the length expected. So all that clarity you will get after this session. Each and every question is simplified for you. I have also highlighted the keywords. Just mention those words in your answer. And I'm telling you, students, many questions are asked from RTP. That is my observation in the last few attempts. So please go through the RTP questions well and prepare them for the exam. Go and download that answer sheet first. Keep it in front of you. Okay. And then let us begin. So the first question, are you ready, guys? Just give me a thumbs up. Are you ready for this session? Don't worry if you're not able to answer all the questions. This is a practice session for us. So are you ready? Just give me a thumbs up. Yes, guys. I'm super excited to be live after a long time. I'm seeing new names and a few familiar names. This time you have to clear law with best marks. Law should be the best paper of your examination. Hi Arun Devan, and a welcome to all of you. Good evening, Riya, Vikas, everyone. Welcome, Ramya, Siddesh. A warm welcome to all of you. I'm so glad that you chose to learn law and improve your knowledge of law. Yes, all right, guys. I'm excited. Hi, Ravleen, how are you? Okay, so Ravleen, your doubt, you had messaged me that there was a doubt on how to write the answers. Okay, so then we are going to discuss that today. Okay? All right, let's discuss the first question. Guys, I am going to just read the question. You have to tell me the answer. Let's read. So, A enters into a contract. I'm going to quickly read it, okay? So, A enters into a contract with B that he, A, is going to sell his house for 10 lakh to B. Further, they both signed an agreement that if B uses the house for gambling purpose, then B shall pay to A 50,000 for it. B agrees to this, but However, after a year of sale, B started gambling business in that house. Can A claim 50,000 from B? Discuss with reference to the provisions of the companies of the Contract Act 1872. Yes. What do you think? What should be the answer to this question? This agreement has two parts. I'm giving you a hint. This agreement has two parts. Hi Sai, how are you? Welcome to your first class. Yes, so in this case, buyer is buying the house and the agreement between them is that he will sell it for 10, the seller will sell it for 10 lakh, and if he uses it for gambling purpose, then he shall pay rupees 50 lakhs, 50,000 more. So what do you think? Should this be valid or not? B has agreed and he started gambling. I'll wait for your answers. Okay, so in this case, the agreement is divided into two parts. One is legal and other is illegal. Do you remember section 24 that if the legal part cannot be separated from the illegal part, the entire agreement is void. Illegal, yes, Ravleen has answered. Dhanu has also answered. I'm so glad. I was waiting for your answer, guys. Ria has answered, no, it is void. See, if you cannot separate, Kinnari, very nice answer. Agreement is valid agreement. Gambling is illegal. Okay. Cannot enforce your hence. If you can separate the legal from the illegal, then the legal part is valid, the illegal is void. But if it cannot be separated, then the entire agreement is void. So over here, the answer is based on that concept, section 24. So let's see what is the expectation of ICAI from us. How have they framed the answer? According to section 24 of the Indian Contract Act 1872. Now, since this is the first question that we are discussing, I will discuss the answer writing format with you, the things that you should write in your answer. First, section number. कौन से एक्ट का है? It is of the Indian Contract Act 1872. You need to write that also. Simply writing section 24 is not sufficient. According to section 24, or you can say as per the provisions of section 24, that is also okay. As per the provisions or according to section 24 of the Indian Contract Act 1872. Now, what is the heading of section 24? Agreement is void if the consideration and object is unlawful in part. This is just a reminder for you. You need not write all this in the exam. It is just for our revision. An agreement with some part is legal, the other part is illegal. Then the question arises whether the contract is valid or not. Whether legal and illegal can be severed, can be separated, can be divided. The lawful part is enforceable and the unlawful is void. So in this case, he sells the house. That part is valid. But if he uses it for gambling purpose, then it is illegal and void. So over here, the part of sale is valid, but gambling is illegal. It is not enforceable by law. Okay. Now, you may also argue that, ma'am, in this case, he is knowing that the house is going to be used for gambling purpose. Then can it be void completely? See, go through the question properly, students. Over here, as per the question, if he uses the house for gambling, so at the time of sale, A was not sure that whether B is going to use the house for gambling or not. He had only said that if you use it for gambling. Okay, so he sold the house and then after a year, B started using the house for gambling purpose. So now the legal part is selling of the house. Then later he came to know that B is using the house for gambling. Now can he recover that part of 50,000? No. So here it is possible for us to separate. We know that sale of house is for 10 lakhs and gambling is for 50,000. So when you can separate, then the legal part is valid, it is enforceable, the illegal part is void. But what if it was for 10 lakhs and they didn't know how much is for gambling and how much is for sale of house? If it cannot be separated, then the entire agreement becomes void. So now in this case, how have they framed the answer? In the first paragraph, you will write the section number. Okay, so please note, I have highlighted what you are expected to write. In the first paragraph, you will write the section number, name of the act, you will write the provisions. In the second paragraph, you will explain facts of the case and you will arrive at the solution. In the third paragraph, you will write conclusion. Okay, so let me put the format for you. Let me write the format for you. In the first paragraph, okay, in the first paragraph, you will write the section number, you will write the provisions, you can also write name of the case law if any. In the second paragraph, okay, in the second paragraph, you will discuss facts of the case and you will offer some solution. And in the third paragraph, they are expecting you to write the conclusion. Now, many of you always ask me that, ma'am, can we write headings? Yes, of course. In the first heading, you can write provisions. Second heading, you can give facts of the case. Third heading, you can give solution, or you can write interpretation, analysis. You can write that also, analysis will be a better word. This is your solution, and in the fourth paragraph, you will give the heading as conclusion. Okay, so yes, you can give headings. Now, leave a line after every discussion. Here also, after every paragraph, leave a line. Now, what if this question is asked for 4 to 5 marks? Half page to 3/4 page of your answer. Okay, so the answer length should be half page to 3/4 page for a 4-mark question. Now, let us discuss the second question. Do you want me to wait? Are you writing it, or you can go through the video later also if you want? Okay. Now, second question. Let us read the question. It's an interesting question. Seema was running a boutique in New Delhi. She has to deliver some cloth to her friend Kiran, who was putting up an exhibition in Mumbai. So Seema delivered the sewing machine and some cloth to the railway company to be delivered at a place where the exhibition was to be held. Now the students who are enrolled with me will quickly tell you that this is based on a case law. Madras Railway Company versus Govind Rao. Yes, so this is based on a case law. Seema was running a boutique. She was sending the cloth to her friend. Seema expected to earn an exceptional profit from the sale made at this exhibition. However, she did not bring that fact to the notice of the railway authorities. Students, this is hint. You should be able to identify the hint, and yes, this is my hint. She did not bring this fact to the notice of the railway authorities. Okay, she did not bring this fact to the notice of the railway authorities. This is your hint. The goods were delivered at a place. I'm not giving you the answer, but after the conclusion of the exhibition. So goods were delivered after the conclusion of the exhibition. On account of such breach of contract by the railway authorities, can Seema recover the profits, loss of profit from the railway company? Yes, I have given you the hint. You tell me whether she can recover the profit or not. Yes, tell me. I'm waiting for your answers. No, yes, Sugam was very fast. No special damages is recoverable as she did not inform the railway authorities. Superb, students. Now, see what are the hints. Answer is given in the question itself, how to identify the hints. The first hint, she did not bring this fact to the notice of the railway authorities. First hint, that she did not communicate. Second hint, she wants to recover the loss of profit. This tells me that she is filing a case for special damages. Okay, This gives me a hint that she is filing a case for special damages. And once you know what the case is about, then your mind should tell you for special damages, it is loss of profit, but you can recover the damages only when special circumstance exist. They should exist. And the second is that she should communicate those special circumstances. So yes, there were special circumstances in this case, but was it communicated? No. No special damage. Kinnari, correct. Vikas, because she did not make any conditions. No, she did not make. No, it will not come. She did not communicate. Sugam, yes, Sugam had already answered. Special damages cannot be incurred. Ravleen, correct answer. Vikas, correct answer. Riya, correct answer. Siddesh, correct answer. So special damages cannot be recovered because special circumstances were not communicated. So let us see what is the answer given by ICAI. As per section 73 to 75. Okay. Damages mean, so first they have explained the meaning of damage. If you don't write section 75, that's fine. Section 73, yes, can be written in your answer. Section 73, when can you claim damages? You can recover only damages if it is a result of the breach, but remote or indirect damages cannot be recovered. So compensation can be recovered only for damages which are a result of the breach of contract. So you can write only section 73, that is fine. Ma'am, if we forget to write 73, we don't write any section, that's okay. You should not feel tensed. Your provisions should be correct. In the first paragraph, meaning of damage. So over here they have explained that when the party commits a breach, aggrieved party can claim compensation. What is the meaning of damage? Then they have explained what is ordinary damage and meaning of special damage. General damages, ordinary damages are those which naturally arise due to the things. Therefore, when breach is committed, the defendant can be held liable for losses which naturally arise in the course of things. But special damages, they can be claimed only when there are unusual circumstances and when they are communicated, when we have communicated, the other party has knowledge of the defendant. If special notice is not given, then the aggrieved party can claim only ordinary damages. They have also mentioned the name of case law, Headley versus Baxendale. In Headley versus Baxendale, special circumstances were not communicated, so he was not entitled to special damage. Now, if I were the student, I would have written Headley versus Baxendale along with special damages. They have written the Headley versus Baxendale mention along with ordinary damages. It's okay. Name of case law is important. Where you write, that is fine. But as a student, I would have written it along with special damages. So you will explain damage. You will explain that section 73, this, what they have explained, no, meaning of ordinary damages, it is a continuation of 73 only. That you can recover damages which are a direct consequence of breach, means ordinary damages can be recovered. For recovering special damages, you should communicate the special circumstances. So in the first paragraph, we have written section number. We have written provisions of section 73. We have explained ordinary damages. We have explained special damages. Now, and also we have quoted Headley versus Baxendale. If I were the student, and if you are my registered student, you will tell me, ma'am, we should also write Madras Railway Company versus Govindra. So two case laws can be mentioned in the first paragraph. Then second paragraph, discuss facts of the case. In the given case, Seema could make exceptional profits, but she did not inform this to the railway authorities. This you cannot copy from the question. You have to write the facts in your own words. Since the goods were delivered after the conclusion, she can recover only ordinary damages. Since notice was not given, she cannot recover special damages. Now, since the notice was not given, this is actually the conclusion. This is actually the conclusion. They have not written it in paragraph form. They have just written it in 2 paragraphs. But we will properly draft the answer. Okay, students? So I hope this question is clear to you. So let us proceed with the third question. Chandan was suffering from some disease. He was in great pain. He went to Dr. Jhunjhunwala, whose consultation fees was 300. The doctor agreed to treat him, but on the condition that Chandan was to sign a promissory note of 5,000 payable to the doctor. Immediately, hint, what is the hint? Doctor, patient. So what should be in your mind? What should come in your mind? Can you tell me? What are they indicating? What are they indicating? Doctor, patient, what should come in your mind? Undue influence. Yes, undue influence should be, that is the hint. It is a question on undue influence. Okay, if it is undue influence, what is the section number that should come to your mind? Do you remember the say? Mental distress. Yes, undue influence. There is fiduciary relation. Good, Arundev, very good. Then what is the section number? Can you tell me the section number also? Undue influence. Yes, you should. It should immediately click undue influence, section 16. Section 16. Yes. So let us continue reading. Now we are ready with, mentally we are ready with the answer. Chandan signed the promissory note, gave it to the doctor on recover. Now the fees was 300. He got the promissory note filed for 5,000. Undue influence. So in this case, on recovering from the disease, Chandan refused to honor the promissory note. State with reasons. Can the doctor recover the amount? Can the doctor recover the amount? Students, what will be your answer? Can the doctor recover? Section 16, Ravleen, superb. Asus, superb, yes. Then Arundev, devil, yes. 16, very good. What is the answer to this question? Can he recover? Hi Jatin, how are you? Good to see you. Okay, so can he recover? No, he cannot recover. There is undue influence, section 16. So your entire answer will be based on section 16, undue influence, fiduciary relation. You gave me the keywords. So in the first paragraph, let's see what the answer should be. Superb, guys, you're doing great, huh? I'm so happy with your answers. Very well answered. As per section 16 of the Indian Contract Act, it provides that the contract is said to be induced by undue influence when the relations subsisting between the parties are such that one party is in a position to dominate the will of the other party and he uses that position to obtain unfair advantage. This can be when he holds real or fiduciary, when he holds real or apparent authority, fiduciary relation, when he makes contract with other someone who is in mental distress. Pure theory, pure definition. Nothing that they have added in their own words. So first definition, meaning of undue influence along with section number. Okay, so you told me all these keywords. Then second paragraph, facts of the case. Section 19A, it provides that when the consent is obtained by undue influence, agreement is voidable. 19 में क्या लिखा है? If the consent is obtained by coercion, fraud, misrepresentation, contract is voidable. 19A, capital A, it was introduced by an amendment. There they have written that in case the consent is obtained by undue influence, then it is voidable. Section 19A, contract is voidable. We have to give the effect also. Any such contract can either be set aside or it can be treated as valid. They are giving the meaning of voidable contract. The benefit must be restored. Can I say this is also theory? It is again theory. Then benefit will have to be restored. So what is written? Contract is voidable, benefit will have to be restored. Okay. So in this case, now they come to the facts of the case. From the facts, Chandan signed the promissory note under undue influence. Hence, Jhunjhunwala cannot recover the amount of the promissory note. He can claim only the normal consultation fees. What if Chandan paid 5,000? Then can he recover that? If he decides to treat the contract as voidable and cancel, can he recover the excess amount he paid? Can he recover? Sugam, is it good? Energetic and enthusiastic, is it good? Or are you teasing me? Are you, yes, Sugam? I hope you're enjoying, because you know, otherwise the session becomes so boring, no? It becomes so boring. Arundev, yes, you can recover. There is restoration of benefit. Restoration of benefit. Yes, very good. Okay, so guys, I hope you're understanding what to write, because you're a lovely batch, huh? You guys are answering everything so correctly. Till now, I have not received any wrong answer. Okay. Mr. Asim, he is a learned advocate. His car was stolen from his house. He gave an advertisement in the newspaper that he will give a reward of 10,000 to whoever gives information about his car. Mr. Vikram reads an advertisement on making some efforts. He got the stolen car. He informed Mr. Asim. Mr. Asim found his car, but he denied giving reward of 10,000 to Mr. Vikram because he says that an advertisement in the newspaper, it's just an invitation to offer. It's not an offer at all. Hence, he is not liable to make the reward. State with reasons whether Vikram can claim the reward of 10,000. What do you think, students? What should be your answer? Oh, thank you, Sugam. I became very conscious. I thought, maybe. Okay. Yes, Ravleen, you have been an excellent student. I also enjoyed interacting with you. Thank you so much. Okay. Yes, guys, I'm waiting for your keywords. What is the hint in this question? What is the hint? 𝗟𝗵𝗿 Shukla versus Gauri Dutt. Jatin, I don't think we should quote that. Because this is not new about... Okay, you can write it, but answer will not be framed that way. Jatin, it is not about 𝗟𝗵𝗿 Shukla, whether you can claim the reward or whether he was aware of the offer or not. It's whether it is offer or invitation to offer. That is the main part. He was unaware of the offer? No. He reads the advertisement making... Okay. I understood, Jatin, now why you are quoting that. Yes, you can write it. You can write. I missed that part. He reads the advertisement. Okay, Jatin, my bad. Yes, you can write that answer. No, Ravleen, he was aware of the offer, no? But the main answer is whether it is offer or invitation to offer. That is what the examiner has written in the answer. Tell me, guys, is it offer or invitation to offer? Invitation to offer. No. If it is invitation to offer, then he cannot recover the reward. Asus Babu. Past voluntary act render for the promisor. No, Nitya, I don't think so. We need to write that. Guys, simply tell me whether it is offer or it is invitation to offer. Advertisement given in the newspaper. Is it offer or is it invitation to offer, guys? Yes, CA aspirant. I have read many comments of yours. Hi. It is offer, guys. It is offer. It is general offer. Yes, Sugam is right. Ramya is right. Riya. I hope you didn't read the answers. Huh? Yes, it is offer. It is offer. It is offer. See, invitation. What is the difference between offer and invitation to offer? I had done a video on offer and invitation. Go and find it on my channel and you will be able to... See, many students have a confusion. What is offer and how is it different from invitation to offer? See, offer is very direct. You can either accept or reject it. Invitation is just a circulation of offer. It comes before a definite offer. Like, if I tell you, do you want to buy this pen? You can either accept or reject it immediately. But if I say I want 1,000 pieces of this, you tell me at what price you are going to supply, then that is invitation to offer. Okay. So this is an offer that I will give 10,000 to whoever finds my car. So in this case, it is an offer. He read it. He had knowledge about the offer. He accepted the offer. He is entitled to reward. Okay, it's an offer. He can claim. Yes, Riya, you are right. Sugam, Ramya, CA aspirant, you are right. Jatin, invitation to offer is not an offer in the eyes of law. It is only inviting the offer from the other person. Superb. Very good, students. Here you made some mistake. Huh? I think I praised you very early. Here, yeah, but then you can't, I can't blame you. That concept is a little confusing. So you can go and refer to my video on invitation to offer and offer. Now, let us go through the answer over here. See, what is the expectation of ICAI? An invitation to offer is different from offer, correct? They have given examples. Quotation, menu card, price tag, advertisement in the newspaper. They are not offers. They are merely inviting the public to make an offer. Invitation comes before. It is precedent. You can write in simple words. It comes before making an offer. acceptance does not result in a contract, only an offer emerges. But there is an exception to the above provisions. When advertisement is made for reward, it's a general offer to the public. So what have they written? I have simplified that. Okay, we should simplify law. It is invitation to offer. What is invitation? It's a circulation of offer, comes before a definite offer. It induces offer from the other party. Announcing the reward in the newspaper, it's a general offer. You can continue writing in this. It's a general offer. It can be accepted by anyone who has knowledge of the offer. He can communicate his acceptance by his action. It's implied acceptance. General offer can be accepted by any person who has knowledge of the offer. So you can also explain general offer. I think this answer is very short. For a 4-mark question, this answer is very short. They have not explained what is offer. So you can add that over here. On the basis of the above provision, it can be said that advertisement is an offer. He knew about the offer. They have not written about knowledge of offer. So he had knowledge of offer. He can accept the offer. He found the car. He is entitled to reward. We can also write the case law 𝗟𝗵𝗿 Shukla versus Gauri Dutt. Riya, we are going to discuss the RTP. Tomorrow we are going to discuss mock test paper. And then we will start with revision lectures. Okay, we'll start with revision lectures. This is basically for students who have already studied, or maybe it is their second attempt. They want a revision for RTP, MTP. So I want to free them first. Then for new students, we are also conducting live revision lectures from next week. Okay. So tomorrow, please meet for MTP discussion, mock test papers. All right. So in this case, we can elaborate, we can add more points. Mr. Singhania, next question. Okay. 5th question. Mr. Singhania entered into a contract with Sonu to sing in his hotel for 6 weeks. It's a very different question, students. Please pay attention. On every Saturday and Sunday, Mr. Singhania promised to pay 20,000 for every performance. Sonu performed for 2 weeks, but on the 3rd week, his health deteriorated and he was in a very bad condition, so he did not come to sing. Mr. Singhania terminated the contract. State in the light of provisions of the Indian Contract Act, can Mr. Singhania terminate the contract with Mr. Sonu? What would your answer be in case he turns up in the 4th week and Singhania allows him to perform without saying anything? What would your answer be in case Sonu sends Mr. Mika in his place in the 3rd week and Mr. Singhania allows him to perform without saying anything? It's slightly confusing, students. It's slightly confusing. So if this question was asked in the exam, what would be your thought process? Siddesh, timing is same, 7 to 8:30. We'll do it within that time. Okay, tell me, students, what would be your thought process in this? Now, Mr. Singhania has entered into a contract with Mr. Sonu to sing. If I was the student, I would have treated this as my keyword, to sing. It requires personal skill, personal consideration. Okay, this is my hint. Personal skill, personal consideration is required over here. This is my hint. Answer is in the question itself. You just have to identify and find that word. So here it is a contract with a specific person. I want that person to perform the contract. Section 40. Contract must be performed only by the person with whom the contract is entered. So in this case, we have entered into a contract with Mr. Sonu. We want only him to perform the contract. Yes, section 40. Let's see the answer. Let's read the answer. So in this case, according to section 40 of the Indian Contract Act, the contract, yes, it must be performed by the promisor because it requires personal skill, personal consideration. So as per section 40, if it appears from the nature of the contract that it was the intention of the parties that the contract must be performed by the promisor himself, then in that case, the contract must be performed by the promisor only. Section 41 is related to the 3rd sub-question. So for now, we will not read it. Okay, so in this case, Mr. Sonu should could not perform the contract. So Mr. Singhania can repudiate the contract. What was the question? Can he repudiate? Yes, because we want the contract to be performed by Mr. Sonu only. If he could not, contract is terminated. It requires the personal skill, personal consideration of that person only. If he is not present, we can cancel. Now, in the second situation, let's read the question again, students. Let's read the question. What would your answer be in case Mr. Sonu turns up in the 4th week and Mr. Singhania allows him to perform the contract without saying anything? So what would your answer be? See, if we are allowing him to perform the contract in the 4th week, then that's fine. No, we can allow him. He can also claim compensate. He can also claim remuneration for us because he has performed in the 4th week. So let's read the answer. This is a very good question. You should mark this and read this question one day before the exam. So in this case, in the second situation, Singhania allowed Mr. Sonu to perform the contract in the 4th week without saying anything by conduct. So Mr. Singhania has given his consent, performed the contract. Now he cannot terminate the contract, but he can claim damages. I have added this for his absence in the 3rd week, because for what can he claim damages? For his absence in the 3rd week, he can claim damages. But will he have to give remuneration to Mr. Sonu for his performance in the 4th week? Yes. Yes. Now, what if Sonu sends Mika and Mr. Singhania allows Mr. Mika to sing? So, if now in this case, can the contract be performed by a 3rd person? Can the contract be performed by a 3rd person? Yes. Personal skill. Ravleen, very good. Sugam, correct answer. Riya, correct answer. Okay. So in this case, can we accept performance from a 3rd party? Yes. If the promisee agrees, he can accept. This is in section 41. That is why they have written that in the answer. It provides that, what is written in section 41? It provides that when the promisee accepts performance from a 3rd person, he cannot later on take action against the promiser. Promiser will be discharged in this case. It is as if he is satisfied with the performance by 3rd party. So over here, that is why they have written section 41. Ma'am, what if we don't remember section 41? It's fine. Provisions are more important here. Section 40, yes, you should remember that. Section 40 is important. So here, if he is allowing Mr. Mika to perform in the 3rd week without saying anything by conduct, Singhania has given his consent. Now he cannot terminate the contract. He cannot claim damages from Sonu because he himself has allowed Mr. Mika to sing. What if he had not allowed? What if he says, no, I had entered into contract with Sonu. I want only Sonu to sing in the concert. Then he can repudiate the contract and he can claim damages from Sonu. Okay, for not performing in the 3rd week. So students, if you have the RTP with you, if you have the copy of RTP, please highlight this as important for exam and you should study this one day before the exam. Please go through this question. Okay. Let us now proceed to the 6th question. Let us proceed. It's a theory question. Anticipatory breach is a breach occurring before the time. Yes, we agree. State the effect of anticipatory breach. Yes, we know the anticipatory breach of contract. I have made notes for you. Section 39. Section 39. This section number is important for exam. Section 39, anticipatory breach of contract. Okay, you tell me. What is anticipatory breach? Tell me. What is anticipatory breach? See students, if you answer no, your concepts will be revised and you will gain more confidence. So I want everyone who is present in this session to answer. What is anticipatory breach? And what is the effect of anticipatory? I'll just hide the answer for the time being. I'll wait for you to type. Sugam, you're very fast in answering. The breach which is conducted before the actual date of performance, yes. Breach which is conducted before the due date of performance. Instead of writing actual date, Sugam, write before the due date of performance. Preeti, yes. Breach before the time fixed, yes, correct. Arundev, he'll again answer. Okay, so yes guys, very good, very properly answered. Ravleen, anticipatory breach means breach occurring before the time fixed. Superb, Ravleen, I'm so happy with your answers. You have suddenly gained so much confidence in law. I think my lectures worked. Beautifully answered. Sugam, effects. Okay, Sugam is ready with the effect. Jatin, in which party declares his intention of not performing before the performance is due. Very good, Jatin. Correct answer. So I think guys, you are writing correctly. Anticipatory breach occurring before. Yes, Riya Bhattacharji. Very good. So breach which occurs before the due date of performance. What are the effects of breach? Sale of houses and agreement valid gambling. Kinnari, I got some previous answer, I think. Okay, so in this case, what is the effect? You can either cancel the contract immediately without waiting for the due date of performance and claim damages, or you can wait for the due date of performance, but on the due date, what if the other party performs the contract? Then you will have to accept the performance and pay for it. But we are waiting, but still on the due date, he doesn't perform the promise. Then you have no option but to cancel the contract and to claim damages. Yes, so students, I have simplified the entire answer in a chart form. Later you can you can relax and then go through this again. It's a purely theory question. You must have studied this many times while preparing for the concept. Okay, Jatin has written I want to read your answer to see if it is correct or not. Sugam, immediately rescind the contract or continue till the due date of performance. Very good, Sugam. If I can treat the contract as operative, we can rescind the contract and claim damages. Jatin, I love the technical words which you have used. Rescind the contract, treat it as operative. Superbly answered, Jatin. Very well answered. Now, yes, it is correct. It is correct. Kinnari, you need to work on the wordings a little. Okay, you need to work on the wordings. Now, let's go to question 7. Guys, if you need practice, okay, if you need to solve more questions, you need practice, then you can refer my law compiler bomb. I'll just share a link of that book. The exam questions will be from that book only, 100% guarantee. Okay, so I'll just share a link of my compiler with you. It is a book containing all past exam questions, study material questions, RTP, MTP questions. Everything is arranged unit-wise. Many of you already have the compiler. I can see the way you're answering. Hi, Swanand. Yes, he is a superbly positive person always. I appreciate your support, Swanand. Hi. Sugam, you have it? All right. I can make out from your answers. That is why you're answering so confidently. Ravleen, Jatin. Swanand, thank you so much for your wishes. Guys, he is a CA finals too. He's a CA inter or final, I forgot. But extremely positive. He also writes blogs. Swanand, you didn't share your second blog with me. I'm waiting for it. So do share your content with us. He writes blogs and he has his own website. Also preparing for CA exam. Okay, students, let's continue. I've shared the link of the compiler, guys. Okay, let's continue. The 7th question. AB is a cloth company. They are dealing in the wholesale and retail buying business. Customized as per the requirement of the customers. They dealt with silk, organdy, cotton, khadi, chiffon, many other different varieties. Mrs. Rima, a customer, came to the shop, asked for, this is the hint. Answer is given in the question itself. This is the hint. She asked for specific type of cloth suitable for making sari for her daughter's wedding. She specifically mentioned that she required the silk cloth which is best suited for this purpose. Now, if she is asking specifically and relying on the skill, the judgment of the seller to select it. Now, I'll not say further, otherwise this is the answer itself. The shop owner agreed, arranged as per the buyer's requirement. When she went to the tailor for getting the sari stitched, she found that the seller has supplied her cotton organdy material. It is not suitable for the said purpose. It is heavily starched. It is not suitable for making sari that Rima desires. The tailor asked Rima to return the cloth as it would not meet his requirements. Now the shop owner has refused to return the cloth on the plea that it was cut to specific requirements of Mrs. Rima and it could not be resold. With reference to the doctrine of caveat emptor, They have again given you a hint. Explain the duty of the buyer as well as that of the seller. Also explain whether Mrs. Reema could be able to get the money back or the right kind of cloth as per the requirement. So what do you think, students? What should the answer be? What should the answer be? Thank you, Pink Flag Army. I liked your name. Okay, yes, guys, tell me the answer. I'm waiting for your answer. I have given you a hint. What will your answer be? So in this case, she has specifically mentioned the type of cloth, she has mentioned the purpose, she has relied upon the skill, the judgment of the seller. The seller has been dealing in those goods since a long time. If you are my registered student, do you remember the car example I had given you? Yes. So, guys, is there some problem? Ravleen, any problem? Jatin, condition section 16, superb. Condition as to quality of fitness, then caveat emptor explain. Yes, Jatin, condition as to quality of fitness. This is it is an exception. It's an exception. Seller is liable to accept the return goods if they are not suitable for buyer's purpose. Very good, Vivek. It is an exception to caveat emptor that if the goods are not meeting the purpose, it's an exception. Yes, she is entitled to get the money as she relied on the skill and judgment of the seller. Very good, students. Now let's read the answer. In this case, there are very specific things which I want you to write. First, explain what is caveat emptor. Okay. Yes, Ravleen, very good. She first explained caveat emptor. What is the meaning of caveat emptor? I don't think I need to explain that to you. Buyer beware. You cannot blame the seller for your bad selection. The seller is in no way responsible for the bad selection of the buyer. Then there are certain exceptions. Fitness as to the buyer, these are exceptions. Fitness as to the quality or use. Then the goods, if they are sold by description, then they must be fit for buyer's purpose. Goods are sold by sample. It's a theory part. Based on the above facts, we can conclude that she is entitled to get back her money or the right kind of cloth. It is the duty of the seller to supply the goods that are reasonably fit for buyer's purpose. I think this answer is incomplete. I think it is incomplete. They should have explained fitness as to the quality. See, there is, students, please note, this is important. There is no quality, there is no condition. There is no warranty as to quality or fitness of the goods. However, if the buyer has made his purpose known to the seller, if he relies upon the skill, the judgment of the seller has been dealing in those goods since a long period of time. If these conditions are satisfied, then yes, we can blame the seller. That they have not written in the answer. I think you should include that. You should include that. If you don't write the other exceptions, I think it is fine. It's a waste of time actually writing the other exceptions list. It's a waste of time. Instead, explain the exception. I think that should be the correct answer. What do you think, students? Shouldn't we write it that way? All right, so the 7th question is done. Let's proceed to the 8th question. A went to B's shop and selected some jewelry. He falsely represented himself to be a man of credit, persuaded B to take the payment by check. He further requested him to hand over the ring immediately. Okay. So on the due date, when the seller presented the check for payment, the check was found to be dishonored. Before B could avoid the contract on the grounds of fraud by A, he sold the ring to C. So I have represented that for you. A by fraud, fraudulently, he obtained a ring from B. If there is fraud, contract is voidable. It means that aggrieved party B has two options. Either treat the contract as valid or cancel the contract. But before B could cancel the contract, A sold the ring to C, who bought it in good faith without knowing about the fraud. Question is, C took the ring in good faith without any notice. Discuss if the sale is made by non-owner is valid or not as per the provisions of the act. Okay, so I have given you the facts, simplified the facts for you. A committed fraud on B. He obtained the ring, but before B could cancel the contract, he sold the ring to C, who bought it in good faith. I think I've got the answers already. Is C the owner? Yes, it's an exception. It is a voidable contract. In case of sale of voidable contract, what are the conditions to be satisfied? Tell me, students, do you remember the conditions? Do you remember the conditions? What is the first condition? The contract should be voidable. Pink flag. Yes, C received a good title. Very good answer. Riya, correct answer. Kinnari, Sugam, correct answer. Nithya, Nemo that con. Yes, no one can give what he has not got. We can write that. But it's an exception, no, to that rule. It's an exception to that rule. We can write that case law. We can write that Latin phrase. Let's see the answer. Let's see the answer now. Yes. Let's see the answer. Provisions are written in the first paragraph. As per section 27, it states that no man can give a good title unless he is the owner. But there are certain exceptions. One of these exceptions is in case of a voidable contract. What are the conditions? Firstly, the contract should be voidable. Contract should not be cancelled. So the sale takes place before the main contract is cancelled. Person has bought it in good faith. He doesn't know that the contract is voidable. Now, students, the logic over here is, because the main contract remained valid, the collateral is also valid. I'll show it to you. See, over here, the sale took place before the main contract was cancelled. So if the main contract was not cancelled, it remains valid. The collateral is also valid. That is why the sale is valid. He took it in good faith before knowing about the previous fraud. The main contract is valid. The collateral is also valid. Okay. So over here, you should write the exceptions and you should write the provisions related to that exception. Now let us discuss facts of the case. Based on the above facts, Mr. A is in possession of the ring under a contract which is voidable. He sells it to C, who takes it in good faith without knowing about the fraud. Since all the conditions, this is analysis and conclusion. Since all the conditions are fulfilled, therefore the ring, the sale made by A to C is valid. It is valid. Let's see if I have received more comments. If you don't have ownership, you cannot pass it to the other person. But this is an exception. It's an exception. This is an exception. Let's read the 10th one. Yes, I think I'm satisfied with your answer. You guys are clear with the concept. Correctly written. Let's go to the 9th question. This is simple. Classify the following according to the types of goods. Okay. Wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales and they were selected and set aside. I am not going to give you any hint. You have to tell me the answer and you have to also tell me how you came to know about it. Yes, guys, I'm waiting for your answer. You can do it. It's very simple. Tell me. Okay, so what is the hint over here? Waiting for your answer. What kind of goods are these? They are no pink flag army. They are not ascertained goods. No, they are not ascertained. Ascertained. No. They are unascertain. Siddesh, correct answer. They are unascertain goods. He agrees to sell and they were selected and set aside. Then they become ascertained. Okay, so earlier they were unascertained goods and now they are ascertained goods. Okay, so you can write both in your answer. You can write both in your answer. So over here, first we will write that they are unascertain goods. Then they become ascertain goods. Yes, then they become ascertain goods. So A, the wholesaler, has 100 bales in his godown. They are unascertain. He agrees to sell 50 bales. They are set aside. On selection, they become ascertain. So how will you start the answer? That he agrees to sell 50 bales out of 100. They are unascertain. But now on selection, they become ascertain goods. Okay. If you write directly ascertain, it is completely fine. They have not mentioned that in the answer. But I always feel that, you should mention that they are unascertain and then ascertain. So it is a contract for sale of ascertain goods. They are identified after the formation of the contract. All right, all right. Next question. Next, you have to identify, yes. A agrees to sell one packet out of 100 lying in his godown. Yes, out of words. It is a hint. Existing goods, yes, you can write existing goods. If you don't write, that's perfectly fine. But unascertain and ascertain, these two words should be present in your answer. That goods are unascertain, then when they are ascertain, they become, when they are selected, they become ascertain goods. Okay, out of, yes, students, it is a major hint that the goods are unascertain. I gave you the answer actually. Okay. So it's a hint out of X out of Y, dash out of word Aya, unascertain. Yes, Jatin, you remember? Out of is unascertain. Good, very good. T agrees to sell S all the apples which he will grow. He will produce in his garden. What is the hint over here? What is the hint? Will be produced. This is the hint. Will be produced. What kind of goods are these? Yes, Pink Flag Army, your answer is correct. Yes, Kinnary, correct answer. Future goods, Jatin, you were the first one to answer. Very good. Out, will be produced. Yes, Pink Flag Army, very correct answer. What is your name, by the way? What is this army? What is your name? Future goods, Ravleen. Yes, you identified my hint. Out of, correct. We had discussed this in the lecture, no? Okay, so future goods. And out of is I'm getting mixed answers actually, because students are answering second and third, both the questions. Okay, so out of is a hint. Next question, let's go to the next question. Certain goods were sold by sample by A to B, who in turn sold the same by sample to C, and C sold it to D by sample. The goods were not according to the sample. Therefore, D, who found the deviation, rejected the goods. He gave notice to C. C sued B, B sued A, advise B and C. Can they recover the loss? What do you think, students? A sold the goods to B by sample, B to C, C to D, then D rejected. Now can B and C take action? Krishna. Okay, lovely name. C can recover from B, B can recover from A. Okay. Can they claim damages? Okay. What about D? D can rescind the contract, others can claim damages only. Why, Krishna? Why have you written that? You are saying that he can only rescind the contract and others can claim damages. Why have you written that? Why can't the others also reject the goods? Krishna? Why can't the others also reject? Hi, Parth. Yes, Ravleen, you can mention implied condition as to sample. That is not satisfied over here. C can recover only damages from B, B can recover damages from A. Why can't they reject the goods to A? Why can't they reject? Okay, now in this case, D, let's go line wise, okay? A sold the goods by sample to B. Buyer is always given an opportunity of comparing the bulk with the sample. He has to inspect whether the goods are as per the sample or not. But B, it seems, without inspecting, sold it to C. And C also, without inspecting, sold it to D. It means that when they had the opportunity to reject the goods because they were not as per the sample, they did not reject and instead sold the goods further. So B cannot reject the goods, C cannot reject the goods, D can reject the goods. Yes, but you can only claim damages because the goods were not as per sample. You cannot reject the goods because your act of selling the goods further showed that you had accepted the defect. Okay, so he found the defect. So over here, let's go through the answer. Students, it's a very nice question. Huh? Mark this also for exam. You will revise this also before the exam. It's a beautiful question. Very well drafted. In the given case, see, I have mentioned, see how I have written the graph. A sold goods to B by sample. B sold goods by sample to C. C sold goods by sample to D. D rejected the goods. He can reject because there is breach of condition as to sample. Goods, they should be of the same quantity. Buyer should compare the bulk with the sample. They should be of same. It's quality. It's quality, but it's my handwriting quality. They should be of the same quality. This is only the theory. Okay. Now in this case, D can, in the given case, D who noticed the deviation can reject the goods. He can treat it as a breach of condition as to sample, which provides that when the goods are sold by sample, they must correspond to sample in the quality. The buyer should be given a reasonable time of comparing the bulk with the sample. C can only recover damages from B. B can recover damages from A. For C and B, they cannot treat it as breach of condition. They cannot reject. This is like breach of warranty for them. Because they have accepted the goods and sold it further. That's it. Students, did you notice something? ICAI has directly jumped to the solution. They have not given any theory properly. So what you will do is you will write the theory. You will write that here there is breach of condition as to sample. Then the goods should correspond with the sample. It should be of the same quality. He should compare the bulk with the sample. You should write that. Then you give the solution that C and B cannot recover because by selling the goods further, they have chosen the to accept the defect. They cannot reject because they did not find any defect. Only D can repudiate. आपके compiler question है. हाँ, ये question है compiler में. Yes, it is in the compiler. Yes. Guys, if you have missed the link of the compiler, I'll share it again. This question is there in the compiler. It's a past exam question, which they have repeated. I'm sharing the link of the compiler again. It is my guarantee that your entire paper will be from the compiler only. All the questions will be from the compiler. I'm telling you. Okay, let's proceed. Next question. Guys, you are well prepared for the exam. Chalo. Good. Let's proceed. Let's read the next question. Sohan, Rohan, Ajay, and Jay, they were partners in the firm. This is there in my compiler. The firm is a dealer in office furniture. They have regular dealings with Messrs. A, B for the supply of furniture for their business. On 30th June, one of the partners, Jay, died in a road accident. The firm has ordered Messrs. A and B to supply furniture for their business when Jay was alive. order was placed when Jay was alive. Keep this in mind. Now Sohan and Rohan continue it in the firm's name, old name, even though Jay has died. The firm did not give any notice about Jay's death to the public or to the persons dealing with the firm. Messrs. A and B delivered the furniture. The fact about Jay's death was known to them. Afterwards, the firm became insolvent and failed to pay the price of the furniture to Messrs. AB and Company. Now, Messrs. AB and Company have filed a case against the firm for recovery of the price of furniture. With reference to the provisions of the Partnership Act, explain whether Jay's private estate is also liable for the price of furniture purchased by the firm. The answer is hidden in the question itself. Tell me, what is the answer? What are the keywords? What are the keywords? Siddesh, yes, compiler is available in the soft copy, but you will have to purchase it. Okay, I don't provide open PDF. Okay, Parth, public notice is one keyword. First, we will explain death of a partner. Okay. Then, yes, Kinnari, compiler का question है, I told you. Compiler का question है, Kinnari, very smartly identified. फटाफट बोल दिया उसने. Legal representative is not liable. But there is one, you are missing out something. Deceased partner is not, Vravleen, very nicely written, deceased partner's estate is not liable after death. Reason, tell me the reason, guys. Tell me the reason. Again, you're missing out on few words. Come on, identify, you can do it. No, Parth. Guys, come on, you can do it. The hint is order. Only order was placed when Jay was alive. Is order a financial transaction? Is placing an order a financial transaction? Accounts, dekho accounts. Is it a financial transaction? No. They just placed the order. It was delivered after his death. Okay, that is one hint. Okay, it was just an order. Second hint. Do we need to give public notice at the time of death of a partner? Is public notice required? Yes, Jatin, public notice death के case में नहीं देते. Correct, Jatin. No public notice is required in case of death of a partner. So here there is no violation. Estate is not liable. Legal representatives, they are also not liable. No, they are not liable. Let us read the answer. Let's read the answer, students. Not required. Yes, correct, guys. This question requires practice, huh? It requires practice. According to section 35, Jatin ने correctly identify किया था section 35, where there is a contract between the partners, the firm is not dissolved, the estate is not liable for any acts of the firm done after his death. It is not necessary to give public notice in case of death. Estate is not liable. A suit for the goods sold, delivered would not lie against the representative. Placing an order is not a financial transaction. So what are the things that you will write? First, the estate of deceased is not liable for the acts done after his death. What is done after the death? Delivery of goods. Placing an order was when he was alive. That is not a financial transaction. So his estate is not liable. Delivery was done after his death. He is not liable. His estate is not liable. Date of public notice is also not required in death. So over here, there is no debt. He was already dead when the delivery was made. It is not necessary to give notice in case of death. So the estate can be absolved. They can be released from the liability. You can write in your own words, no problem. Just write the things that I have highlighted. That should be present as it is. Rest you can write in your own words. Okay, students, did you understand how to identify the keywords, how to identify the hint in the question itself? Next, we will discuss question 12. Question 12. Moni and Tony were partners in Messrs. Motto and Company. They admitted Sony as a partner in the firm and he's actively engaged in the day-to-day activities of the firm. There's a tradition in the firm that all active partners will get monthly remuneration of 20,000, but there's no express agreement. After admission of Sony, Moni and Tony were continuing to get salary, but they did not give it to Sony. Sony claimed his remuneration, but he was denied by the existing partner, saying that there is no express agreement for it, whether he can claim remuneration. This is the first time that ICAI has asked such type of question on the concept. Please mark this as important for exam. Study this one day before the exam. They must have asked this previously, but very first time they have framed the question in this manner. So what do you think, students? What is the hint? What is the hint? What is the hint? There is no agreement. Okay, there is no agreement, but it is a tradition in the firm. Yes, what is the hint? Unregistered, Parth. No, that's not the answer. Nahi, Jatin. Active partners, no. Equal share, no. It is about remuneration, guys. It is about remuneration. Yes, I'm waiting for your answers. Yes, Krishna, you are right. Tradition of the firm, this is a hint that they are talking about trade customs usages. This is a trade custom usage. Now, students, pay attention. What is the provision relating to remuneration? Partner is entitled to remuneration only if it is mentioned in the deed, or if there is a trade custom, if there is tradition, usage. Here, even though there is no agreement, but it is their trade custom not to give remuneration. So here Sony can claim because there is remuneration which is accepted by the trade custom. That should be your answer. No, there is no agreement, but there is trade custom. Yes, you can claim remuneration because there is tradition. Krishna, your answer is correct. Others, you can still improve your answer. So over here, by virtue of section 13A, a partner is not entitled to receive remuneration, but this rule can always be varied by an agreement. If there is an agreement, he will get remuneration. He can also claim remuneration when there is a trade custom, when there is usage of trade. So here it is customary, so he can claim even if there is no agreement. So existing partners are getting monthly remuneration. He is also working, admitted as a working partner, as an active partner, so he is entitled to remuneration. Okay. Then question 13. Jatin, you had mentioned about active partner, but that is not what should be highlighted. The fact you should highlight is that even though there is no agreement, there is a trade custom. That is why he is entitled to remuneration. That should be highlighted. Otherwise, you can write about active partner, but sometimes, we start writing more about that. So if you just mention and leave it, it is fine. But don't go to explain it. Okay, Jatin? इक्वल शेयर तो नहीं आएगा यहाँ पर. एक्टिव पार्टनर्स का एक्सप्लेन कर सकते हो, बट ज्यादा मत करना. नेक्स्ट क्वेश्चन. Messrs. X, Y, Z and company, they are partners. Firm is unregistered. The firm has purchased some iron rods from another partnership. So LMN, they are creditors, which is also unregistered. Guys, again, Superbly drafted question. Mark this also as important for exam. This is the first time that they have framed the question in this manner. The firm purchased some iron rods from another partnership firm that is also unregistered. XYZ could not pay the price within the fixed time. LMN, they have filed a case, creditors have filed case against the unregistered firm for recovery. Whether LMN and company can sue XYZ? Yes, tell me. It's an easy question. I don't think you will struggle with this. Yes, guys, I'm waiting for your answer. Can creditor file a case even though it is unregistered? Ideally, no, you cannot file a case. But here in this case, they can file and recover, and you will have to pay. The unregistered firm, that is XYZ data, will have to pay. Ideally, it should not be able to file a case. You cannot file case against a third party, but as a creditor, yes, you can. So over here, where's the answer? Oh, I'm so sorry. I linked it with another question. No, they cannot file a case because it is unregistered. No, I answered the second question first. Okay. So over here, LMN cannot file a case because it is an unregistered firm. They can try to recover, but they will not win because it is a third party. According to the provisions of Section 69, an unregistered firm cannot file a case against a third party to enforce any right arising. This section does not prohibit a third party to file a case against the unregistered firm. Okay, so unregistered firm cannot sue the third party, but case can be filed. But here, since LMN, that it's an unregistered firm, so yes, it cannot file a case. Let's read the second question. Where is it? Yes. What would your answer be in case XYZ is a registered firm, but LMN company is an unregistered firm? So the debtor is registered, but the creditor is unregistered. Yes. Now you tell me, can the creditor, an unregistered firm, file a case? Will your answer change or will it remain the same? Will your answer remain the same? It will remain the same. The person filing the case is not registered. Okay, here the firm is unregistered. It cannot file a case. LMN cannot sue XYZ. Okay. What would your answer be in case XYZ? Let me see the question. Yes. What would your answer be in case XYZ is an unregistered firm, but LMN is a registered firm? So creditor is registered. Now can it file a case? Now can it file a case? Same answer. Yes, same answer. Okay. Now can they file a case? The firm which is filing, that LMN is a registered firm, so it can file a case. LMN is a registered firm, so it can. I'm getting answers of the previous question, I think. I'm getting answers of the previous question. Yeah. Okay. So in this case, I'll just write it over here. LMN is registered. So yes, here no, and here also no. Okay, this makes us clear. Students, I have a question for you. Extra question. Extra question. I have an extra question for you. Ready? Ready for extra question? What if the firm, before filing a case, got itself registered? Can they file a case? The firm got itself registered before filing a case. Now can they file a case? They got the firm registered before filing a case. Yes. But what if they got the firm registered after filing the case? They got it registered after filing a case. Then they got the firm registered after filing the case. If you register the firm after filing the case, at the time of filing you were unregistered, case is not valid. Parth, correct answer. Jatin, correct answer. Yes. So you have to get your firm registered before filing the case. At the time of filing the case, you should be registered. Yes, correct. Next question is a theory question. I think we are almost coming to an end. Yes. LLP has an alternative form which gives the benefit of both limited liability and the flexibility of partnership. It's a very simple question, students. It's a very simple question. LLP gives the benefit of limited liability and the flexibility of partnership. Correct. It gives the flexibility of partnership. You can frame your own agreement. There is no regulation, like you need not have a memorandum articles which is drafted as just as it is in the Companies Act, and it gets the benefit of both limited liability company. Therefore, there is flexibility. So it's a theory question. I'm not discussing it now. This Jagannath Oils Limited is an important question, and I had read this question some time back. I can't recollect where, but yes, it is a repeat question. It's a repeat question. Okay, it's a repeat question. Jagannath Oils is a public company having 220 members, of which 25 members were employees during the period 1st April to 28th June. They were allotted shares in Jagannath Oils first time on 1st July 2007, which were sold by them on 1st August 2016. Now, it is very important for you to prepare a timeline while reading. There were 220 members. 25 were employees. They were employed from 1st April 2006 to 28th of June 2016. It means they left the organization on 28th June 2016. They sold the shares in August 2016. After some time, on 1st December 2016, each of those members, now this is after they ceased to be employees, they again acquired shares and which they are holding till date. You have to decide whether now the company wants to convert itself into a private company. State with reasons whether Jagannath Oil is required to reduce the number of members. Yes, tell me, are they required to reduce the number of members? With this timeline, you can now understand. So, were they members? Were they employees when they purchased the shares in 2016? They sold, then they acquired again. So, should we continue to treat them as employees? Will they be excluded from calculate? Maximum number, Parth, maximum number of partners nahi, maximum number of members is 200. Yes, Parth, go to the e-note section of my website. Go to the e-note section and you can download my annotated RTP. I'll just share the link also with you. This is the link you can download. So, will they be considered as employees? Do I need to reduce the number of members? What is your answer? See, they have left the organization. Then when they purchase the shares again, they are not employees, no? They are members only. So now we will not exclude them from the number of 220. So yes, reduce karna hoga. No, Krishna. See, they are ex-employees, but they should continue to retain the shares, na? They sold the shares. Then they bought again. If they were continuing to hold the shares, then we would have excluded them. But here they sold and then they bought. So they will be considered. The company is required to reduce. Okay. See, this is very important. They sold. If they had not sold the shares and they continued to remain the shareholder, then we were not required to consider them in the calculation of 220. Let's read the answer. So over here, you will first explain the definition of a private company. Okay, step 1 is define private company. You understood, no, Krishna? See, this is the benefit of going through the RTP, because you can make mistakes now and avoid them in the main exam. So here, according to section 268, clause 68, we have defined private company. Then over here, they will be considered as members even though they have ceased to be employed. They will be considered for the calculation of 200. The company is required to reduce the members before converting because they sold and then bought. Okay, second question. Let's read the second question. What is the second question? Would your answer be different if the 25 members were employees for the period 1st April 2006 to 28 June 2017? If they were employees till 2017. So in this case, what will your answer be? Yes, they are ex-employees, but they want to convert, no? After some time, now they want to convert. Okay. So over here, at the time of conversion, even though you were ex-employees, you continue to remain the shareholder. So they will not be included in calculating the number of. They should have actually given the date of conversion. I think they have not given, no? They have not given the date of conversion. They should have given it in the question. They have just said that now they want to convert. Now means when? What is the date? So you will consider that even though they are ex-employees and they continue to remain the shareholder, they will not be considered for the number of 200. Okay. Next, ABC, it has set up a new club. They do charitable work, social activity. They have obtained the status of Section 8 company, but it is observed that they are violating the objects of the Act. Decide what powers can be exercised by the central government in such a case. You are a Section 8 company. You are not supposed to declare dividend. You cannot distribute your profits in the form of dividend. You cannot, whatever profit you earn, you have to employ it for the purpose only. They have violated the objects. They are now doing some kind of profitable business. So what will happen in this case? What will happen? Yes, tell me what you will write over here. It's a theory question, guys. It's a theory question. You will explain Section 8 company. Perfect. The ROC, the license will be revoked. The central government will revoke the license and now the ROC will add the word limited or private limited in the name. Very good, Parth. Krishna, correct. Parth, correct answer. What else? Yes, Parth, very good. They will now, you will be merged with some company having either wind up or merge with some company having similar objects. Perfect. Yes, we will revoke the license. Perfect. So let us see what they have written in the model answer. In the model answer, first they have explained the meaning of a Section 8 company. This is purely theory. Explain the meaning of Section 8 company, that it can perform only selected objects. It can use the money only for the objects for which it is registered. License is given by the central government. Here in this case, they have violated the provision. So the central government may revoke the license if they feel that the affairs are conducted fraudulently, they are violating the provisions, objects, or prejudicial to the interest of the public. On revocation, ROC will then add the word limited or private limited. Parth, you said this. But before revocation, obviously, central government will give you an opportunity of being heard. If the central government is satisfied that it is in the interest of the public, they may either wind up the company or amalgamate that company with another company having similar objects. But again, we will give the company an opportunity of being heard. Now, the things that I have struck off, they are repeat points. वो गलती से print हो गया शायद ICIC. So they will form a single company with such constitution, property, rights, privileges, obligations as specified in the order. So instead of writing all that, if you write company having similar objects, that is also fine. If suppose you forgot to form a single company with such constitution, properties, power, rights, liabilities, duties as may be specified in the order, if you forget to write that, simply write that you will give them the right to form a amalgamate with a company having similar objects. That is also fine. So students, you have given me the right pointers. Good, very good. Nicely answered. I think this is the last question. An employee, Mr. Karan, signed a contract. Okay, let's go through the question. Employee Karan signed a contract with his employer ABC that he will not solicit the customer after leaving the company's service. But after Mr. Karan left ABC, he started his own company and he started soliciting the customer for his own business. Students who have my notes and my lectures will quickly tell me name of the case law, because we have discussed that. Name of the case law. What is the name of this case law? Do you remember? 𝗟𝗲 Motor Company versus Horney. Yes, correct. So in this case, they solicited. Now he is saying that there is corporate veil. The company had agreement with Mr. What is his name? Karan. There was no agreement with the new company. It's exactly the case law. Now, many a time students ask me, ma'am, should we explain the facts of the case? You can do that, but I don't think ICAI has gone to specifically explain the case law. They have not written the facts, they have only written name of the case law. 𝗟𝗲 Motor Company versus Horney. So first explain what is corporate veil. Explain lifting of explain that the liability is limited. Liability of the company is liability of the company only, not the members. This is the concept of corporate veil. So first explain corporate veil. Don't start your answer directly by lifting of corporate veil. First explain what is a corporate veil, then give the circumstances, then explain what is lifting of corporate veil. Then after explaining corporate veil, you will explain what is lifting of corporate veil. Promoters, the persons who are directly responsible, they will be held personally liable. Then mention the circumstances where corporate veil is lifted. Now they have come to the case. 𝗟𝗲 Motor Company, the company was created to avoid the obligation that therefore Mr. Karan and the company this is created, it is only a sham, it is a hoax, it is just to hide the perpetrator of fraud. It is defeating the law, hence the corporate veil is lifted. He is personally liable. Students, I think over here you can write it in your own words and I think you can write better. They have not written the answer completely. In fact, they have written the circumstances where corporate veil is lifted. They have given more importance to that. I think you can explain the case law. That is what I feel. You can explain the case law in your own words. You can also write that in this case, the company is formed as a sham, a hoax to conceal the perpetrator of fraud. It is used as a shield. You can use all these words, which ICA has not done over here. So if you feel that, ma'am, can we write those points? That's perfectly fine. Okay. So students, I think with this we complete the RTP discussion. It's over. Tomorrow we will discuss MTP. Why don't you do one thing? Why don't you go through the questions of mock test paper and prepare your answers in a rough notebook? Write the pointers. Don't see the model answer. Huh? Write what you will write, and when we discuss it in class, you can compare whether you wrote those correct pointers or not. Then we'll read the answer. Tomorrow also I will give you a same annotated MTP which you can refer in the exam, refer one day before the exam, so that everything is, you know, quickly recapitulated. You are able to identify what exactly is to be written. Now for exam you need not read the entire answer over here. You can just read what I have written, what notes I have written on the left hand side. MTP part, it is available on the website of ICAI. I'll share the link if you want. Go to the website of ICAI. I'll share the link. You can download it from there. Here. It has all the mock test papers. I'll share the link with you. जतिन, ये PDF है मेरे वेबसाइट पे, मैं वो भी लिंक आपके साथ वापस शेयर कर देती हूँ. ये है मेरे वेबसाइट पे, आप डाउनलोड कर लो. फ्री डाउनलोड है, नो रजिस्ट्रेशन रिक्वायर्ड. जतिन यहाँ पर है, देखो. केस लॉ ऑफ कॉर्पोरेट वेल्थ, सोलोमन वर्सेस सोलोमन. कृष्णा आप लिख सकते हो, लेकिन नहीं भी लिखा तो चलेगा. इट्स ओके, बट गिल्फर मोटर कंपनी वर्सेस हॉर्ने हैज टू बी मेंशन्ड. दैट इज मोर इम्पोर्टेंट. अरे वो सेम लिंक आ गया लगता है, एक मिनट. हाँ, जतिन आई एम शेयरिंग इट अगेन. यहाँ से आप डाउनलोड कर लो. ये क्यों नहीं हो रहा है? देयर इज सम एरर. एक मिनट. हाँ, बार बार वही लिंक शेयर हो रहा है. ओके, just go to the e-note section. I'm not able to share that link. पता नहीं. हाँ, वही बोल रही हूँ जतिन. मेरी वेबसाइट, आई एम नॉट एबल टू शेयर द लिंक. वो ICAI का ही लिंक बार बार शेयर हो रहा है. आप एक काम करो जतिन, मेरे वेबसाइट के e-notes में जाओ. वहां पर आपको ये मेरी आंसर शीट मिल जाएगी. यू कैन डाउनलोड विदाउट एनी रजिस्ट्रेशन. कोई रजिस्ट्रेशन नहीं करना है, ऐसे ही डाउनलोड कर सकते हो. e-notes ऑफ माई वेबसाइट. ठीक है. कल भी जब हम MTP के लिए मिलेंगे, आई विल प्रिपेयर दिस फॉर यू. हाँ, ऊपर है लाइव चैट में. आई हैव शेयर्ड. या मैंने पिन किया है वो मैसेज, देखो. आई हैव पिन्ड दैट मैसेज. अभी आया वो लिंक. जतिन ये लो. ठीक है, चलो. सो गाइज, टुमारो वील मीट फॉर MTP मॉक टेस्ट पेपर, and after that week we will meet for revision lectures. I will revise the entire syllabus with you. पूरा syllabus revise करेंगे, all the acts, and it will be in English only for all the audiences. Thank you so much, Krishna. Next time, can you do me a favor? I don't want you to write this. You have such a beautiful name. Why don't you change your name so that, you know, I remember you and I can refer it with your name. Chalo. Guys, I'll take your leave for the day. What can I do for CA? What a general question, Mohammed Saif. For CA study, that's it. Okay. So, attend the revision lectures. You'll come to know. Yes, Parth, I saw, but I was very busy today, so I'll reply it at the end of the day, maybe at night. I saw your messages. I'll reply later. Okay. Chalo guys, good night. Enjoy your dinner, and I'll see you tomorrow again at 7 o'clock. Alright? Chalo, bye bye. Good night, everyone. Please leave your comments. Please leave your comment in the comment section. I want you to write whether you liked the session or not. I want you to comment in the comment section. Yes? Okay, Ravlina, I'm happy with your progress. I can see your progress. Hi, Ram Babu, how are you? Long time. Bye Jatin. Bye Parth. Bye everyone. Leave your comment in the comment section, guys. Thank you so much, Krishna. I'll also wait for you. Bye bye. Bye Kinnari. Bye. Bye. Good night, everyone. I'm ending the stream here. And do leave your comment and also subscribe to your channel. It's not mine, it's your channel. You request and I make videos for that. Ravleen, today I received your request and I think this is what you requested. Yes. So bye everyone and do subscribe and leave your comments. I'm ending the stream here. Good night. I'll see you tomorrow with the MTP discussion. Bye bye. Bye.